Okay, all right. So thank you all again for joining tonight's section. Earlier on, I was saying it's Friday and you're here. All right, thank you for. I mean, you could be somewhere else to be honest, but thank you for accepting to be a part of our this session today. I can't imagine training myself. All right, but I'm glad that you make it. I suspect that you enjoyed it the last time. That's why you're back again. And we're going to try between myself and Yinka, and if Mr. Ariboji joined us later on, we're going to try our possible best to make this webinar what the wow for you. I mean, it's free, all right. But one thing that we don't do is we always try as much as possible to give our utmost best to everything that we do. All right. So whether it's paid or whether it's unpaid, um, trust me, we'll try our best and we'll make it fun and also interactive as well. So please, if you have question, you could use raise your hand. You could type in the box. If typing in the box is difficult, just write it down. All right. We would make sure that we can all ask our questions and hopefully get the response that you desire. All right. So welcome again, host Minka. Like I said, hopefully Mr. Ari Boje would join us at some point. Yinka, once you cite Ari, just let me know. All right, so that I
Yeah, yeah.
can, acknowledge him and this. I mean, acknowledge his presence, and and we can do this together. All right. So the topic for discussion today is vendor contract review, and we're going to be looking at GDPR clauses. We're going to be looking at where I have IS there. The IS just stands for information security. Then we're going to be looking at master service agreement as well. So this perhaps would be the maybe the seventh or the eighth in the series of our third party risk
Uh,
management webinars. All right, that's the series. So if you're new to my platform, if you're new here, Inka wanted to say something.
yeah.
All right.
For
So
some
if you're
reason I
new
was
here,
kicked
if
out.
you're new to,
Sorry.
um, you know, uh, uh, you were kicked out.
Yeah,
Okay.
about a minute again, so it's fine.
Well,
It's
you're
okay.
back now, isn't it? All right.
Yeah.
Okay. All right. I mean, please just keep an eye. I don't. I think everything is fine. There shouldn't be a problem. All right. So this like I said, this would be the seventh or the eighth series of our TPRM. All right. So we've had series of training, particularly training. I mean webinars on third party risk management. And the way we have created our topic, they are all interlinked. As a matter of fact, what I'm going to be showing you today, some of my slide of the content. If you've been following my my series on TPRM, you may have seen some of them before. All right, so the topic is carefully selected, the content is carefully created as well to just make sure that it kind of just follow a logical order in a way that you would understand it. Okay, so spell with me. Give me a sec. All right. Okay. All right. So we're gonna start with slide number two. All right. And slide number two. I'm just taking you a little bit back. All right. So I said something earlier on. This is the eighth series of several webinars that we have had on third party risk management. If you're in one of my webinars, perhaps the intention today is not to take you through each phase of this workflow. There are about six phases there. That is not the intention. As a matter of fact, I do not intend to keep you for long here tonight. All right, we just want to have this discussion in 1 hour, worst case scenario 1.5 hour, and we're done. All right. So phase one, which is planning. Number phase two, which risk classification. Phase three that I call due diligence and selection. Then phase four, contract review and negotiation. All right. Phase five is ongoing monitoring and oversight. Then number six, all right, I call it termination and exit of relationship. I think somebody has got a noisy background there. I'm not sure who that is. All right, Timothy, Enoch, please just keep a eye on it for me. All right. So we've got the six phases. In previous webinar, I've already explained all of these phases. All right. So, like I said today, I'm not going to, walk you through and start to explain each of the phases again. If you wanted to learn what each of the phases are, all right, all you just need to do is just to sign up, register on our portal, which is the Smart Learning Portal, www.smartlearninguk.com. That's all that you have to do. Once you do that, you would automatically, the system will automatically create a dashboard for you. And in your dashboard, we will push all the content, all the videos that we've done in the past on TPRM. You would have free access to them. All right. And part of those ones that we've done, we've already covered phase one to phase six. But you see, because of our topic, because of what we're discussing today, someone says my screen is blank. Is my screen blank?
No,
No,
I
it
can
was
see.
blank at the start, but it's clear now.
Yeah.
Am I not?
Even now it's
It's
still
clear now.
blank from my side. It's blank here. I can't see nothing. And
All
it's
right.
playing somehow on my mobile device. Maybe I need to go on the desktop. I don't know
Maybe
why.
just log out and log it again.
All right. Who else is the presentation is blank on your side? Who else? So I think it's just you, Abby. Enoch, you're okay.
Yeah. It is fine now.
Enoch,
It is fine now. It is
it is
fine
fine.
now.
And you can see
Yeah,
my
I can see
slide.
everything. Yes.
Okay. All right. Okay. So yeah, if anything, just text me. We can. All right. So thank you for that. So we're just gonna be focusing on the phase four, and phase four is where I'd call it contract review and negotiation. All right, and that's what we're gonna be talking activities that I have under contract review and negotiation. You see some key activities that are legal authorization. Then I also mentioned the embedding, master service agreement or infosec clauses into a contract. But before you get to phase four, all right, in this workflow, there are other three phases that precede it. All right. So again, I'm not going to be talking. Right, we talked about planning. Then the second phase is risk classification. All right. So this is where you are, as it were, carrying out you're calculating the inherent risk that the vendor could introduce into your organization. So meaning that if you're going to go, do some piece of work, no, not do some piece of work. If an organization is going to do some piece of work, for your own organization, all right, part of, all right, your TPRM, process, one of the things that you wanted to do at the early stage is for you to calculate what we call the inherent risk. All right. So we talked about that in our previous training. That calculation, most organizations will use some set of tooling. All right. When I say tooling, not just anything very heavy. All right. It could be a spreadsheet that has been customized, that some calculators has been embedded into the spreadsheet. The whole idea is to use that spreadsheet, which is a set of questions, question based, to calculate all right, the inherent risk that the vendor, could introduce into your own organization. Then that will now lead to what we call tiering. All right, you can tier your vendor, all right, on the basis of that risk. And one of the things that we said in previous class is when you tier your vendor, you could tier them into three categories, all right, or three levels. Tier one could mean that they are high risk vendor. Tier two could mean that they are low or they are medium risk vendor, and tier three could mean, all right, that they are low risk vendor. In some organization, they could have up to four tiers, all right. Four tier, maybe tier one could mean that they are critical vendors. Tier two could mean that they are high risk vendor. Tier three could mean that they are low risk vendor, and tier four could mean that they are so tier three could mean that they are medium risk vendor, and tier four could mean that they are low risk vendor, all right, depending on the tiering in that organization. But the takeaway there is, these are a set of key activities that you would carry out, all right, under risk classification. This is very, very important, and I want you to note this, because we're still going to come back. I'm going to touch on it at some point in the course of the webinar. Then on the phase three is where you actually now do the due diligence. All right, now the risk that this organization could likely introduce into your own organization. Now you actually wanted to some set of questionnaires that you're going to send to them, based on the level of their tier. All right, so based on the risk, all right, that you perceive that they could introduce into your organization. So again, you put together some set of questions, you send it to them, they respond, you review those responses, you check whether you do the due diligence, you identify where the control gaps are then faced. All right, so of course when you do the due diligence, what usually will come out of that would be reporting as well. All right, there will be nice report that will cause. So of course you would based on the due diligence that you've carried out, there will be findings. All right, there will be things that you have identified. It could be control gaps. It could be something that you expect them to have and they do not have. It could be like they don't have a policy, they don't have sufficient policy in place. Or it could be that, oh, maybe their access control is not great enough. Or it could be that, oh, they are not complying to GDPR. All right, or it could be that, oh, um, um, they don't have sufficient, not sufficient, they don't have, a very, very robust, incident response management plan. All right, so it could be anything, that can come out, all right, of that due diligence. But whatever comes out of it would end up in your report. And what came out of it is what we call findings, and those findings would end up, all right, in your report. All right, so let's assume that you've done phase number three very well and you're happy. Guess what? If you decide, to to if you decide to continue with that vendor based on what you found, then that will now lead us, all right, to phase four. And that phase four now is what we're going to be talking about today, which is contract review and negotiation. So, as it were, in phase three, this is where the infosec individual or the person that is wearing the GRC art is performing most of the activity there. All right, they are the one that is drafting the questionnaire. You are the one engaging, all right, with the vendor, sending those questions to them, getting the response back. That individual, which is the infosec analyst or GRC analyst, you are reviewing the responses, all right, and also you are calling out all of your findings, and you're drafting the report. All right, you could see that under phase three, that activity, all the entirety of phase three, is own. The entirety of phase three, is the responsibility, all right, of the infosec analyst or the person who is wearing the heart of a GRC analyst. But guess what? your report and your findings, all right, go to the entire stakeholder. But now, you pass that vendor, all right, to the legal team. So the entirety of contract review and negotiation, all right, is owned by the legal team. All right, legal would have the overall responsibility. So this is where they are now exchanging contract between both companies. Review is being carried out. All right, don't forget here that legal lead that space. All right, the entire workflow, the entire workflow is owned, most times could be owned by the procurement team. But for each phases of this workflow, phase 1 to phase 5, you would always find that, maybe a particular business unit in that organization would have the overall responsibility. So the case, for contract review and negotiation would usually be spearheaded, all right, it would usually be spearheaded, all right, by the legal team. Not to say that you won't have other department, supporting it as well. Of course, InfoSec will play, a part, all right, in reviewing the contract, but they do not own, they don't own the responsibility in its entirety. All right. So legal is legal, if you know what I mean. They wear their legal hat, making sure that they dot all the I's and cross all the T's. But however, you will find quite a number of SMEs, particularly InfoSec and GRC, supporting, our legal in that space as well. So, here there would be service level agreement if there's, if one is required. There would be a whole lot of, looking at GDPR clauses, looking at information security schedule, and baking all of that into the contract. All right. So I'm going to stop at 4. I'm not moving to 5 or 6 because 5 and 6 is not part of our discussion today. All right. But don't forget number 3, which is phase 3 there, is largely driven, all right, by the InfoSec or the GRC team. All right. Okay. And number 4 is largely owned or driven by the legal team. So, keep focused. Don't lose focus of those key activities, because we're going to be coming back to that shortly. All right. So now that we know that phase 4 is all about contract, review and negotiation, then
Hello.
the
Sorry.
question is,
Sorry, sir. I'm just seeing your screen now. Can you just return to the last screens, please, where you have the faces,
all right, you can't, no, hold on, you
please?
can't interject me like that, please. Yeah,
I'm sorry because
it's
I wasn't seeing
you're
your screen. It
obstructing the
wasn't
flow.
showing
If you need
since. Yeah.
anything, yeah, if you need anything, put in the chat box. All right, I would look at it and I would come to it. All right, it's
Okay.
difficult. You know what I
Okay.
mean?
Yeah, I understand.
All
Yeah.
right, maybe you have to reboot your computer or something like that.
Yeah,
Yeah,
it's not just working for me here.
put it
It's fine.
in the chat box. Yeah, put it in the chat box. Do any other person have a problem?
No, it's
You know,
working fine, Wale.
it's working. Okay,
Yeah.
I don't know. Yeah, so maybe you have to restart your computer. All right, sorry. All right. So now we're going to be talking about the vendor contract. Okay. So we earlier on we've kind of laid a foundation. That negotiations would happen at phase 4. Then the question that we ask ourselves is then what is vendor contract? All right. So vendor contract, in other words, in the real world, you may not hear the word contract. You can hear the word agreement. Okay, it's the same thing. Okay, so it's a business contract between two parties, covering the exchange, of goods and services in return for, a compensation. And this is true. All right, most of us, we exchange contract. If you're an house owner, in this part of the world, all right, the moment you're making your purchase, okay, you're exchanging contract, all right, with whoever is selling the house to you. You would have to append your signature. I mean, just recently I went to go buy a new TV. All right, and when I was leaving Corey's, they gave me the, something to sign, and I append my signature. All right, so contract is, what all of us are familiar with. All right, but the takeaway here is sometimes, they don't call it contract; they use the word agreement. So I'm not a legal person here. I'm glad that Yinka is here. So Yinka, maybe you can clarify that, and whether there's a difference between contract and an agreement. Perhaps you can help me in that area. But again, what is important for you to know is that contract kind of establish a
Sorry, Wale,
business
can I just?
relationship. All right, go on, mate.
Yeah, sorry. Well, I was kicked out
Go
again.
on.
I don't know why that happened, and my screen has gone blank.
Your screen has gone blank as well.
Yeah, it's just
Okay.
gone blank now. It was fine, but then I was kicked out. Yeah.
Okay.
But I think I just caught the
Okay.
last. Sorry, I just caught the last thing you said, which is contract and agreement. Am I correct?
Okay. Yes, I was
Yeah.
just saying that if you can weigh in on that one,
Yeah, yeah, I can.
if there's any difference whatsoever,
Yeah.
on it. Just hold that thought. We're
Okay.
gonna come back to it. Just
Okay.
hold that thought because
All right.
we're gonna come back to it. All right. I
Okay.
don't know what is the issue with the blank screen. To be
Yeah.
honest, yeah.
It
But you
was
can
fine,
hear my
but
voice.
yeah, I can hear your voice. It was fine right up until the last
Okay.
minute, and then it just went
When
off.
initially when I joined on the mobile, yeah, it takes time to load. Everything was blank. I
Mm-hmm.
can hear your audio. I moved that to the computer. The same thing apply. It takes time
Mm-hmm.
from the first slide, second slide. I can't see anything until now that it started showing. You get what I'm saying? So it could end up showing for others as well. I think it got to do with workload or something. I don't know.
Okay. Thank you. We'll look
So
into that. All right.
yeah.
Thank you.
Yes,
Okay.
but I'm having the same
All right.
issue. I cannot. The screen is blank. I can hear you very well, but I can't see nothing on the screen. I can hear you very well.
Okay, yeah. Thank you
My
for all
screen
of
is
the
blank.
feedback. It might just be something that is, I don't know why. All right, but we'll look into it. I'm sure
Okay, thank you.
Enoch is listening. All right, I do apologize. Just pay rap attention, but we'll make it more
Okay.
interactive. I think I get it that you wanted to flow with the slide because it can also be it can be difficult.
Yeah.
But yeah, we hope you become a bit more stable and yeah, but we would just bear with me and flow with me. All right, okay. So we were talking about the vendor contract. So I was saying that uh Yinkard's going to help us at some point, but again, what is the takeaway here? For every time that you enter into an agreement with every time a company enter into an agreement into another company, of course there would be an exchange of contract. Okay, so we know that we so it's not anything new. All right. The next slide, if you can see it, I wanted to talk
Yeah.
about the importance of vendor contract or agreement. Because if it's not that important in that workflow that I showed you earlier on, it wouldn't be there. All right. Especially since we've established that when you enter into a relationship or when an organization enter into a relationship with another organization, of course, all right, then there would be an exchange of contract. All right. So these are the few important. All right. I mean, there are things that but I just wanted to bring it, to your consciousness again. I mean, and if you do not know it, then maybe that's fine. So number one thing is clear expectations. All right. So what a contract would do is it would help in clearing or defining the expectations and the responsibility of both parties. All right. So if you work for an organization and your organization are going to go, purchase maybe a SaaS, services, maybe your organization is going to go purchase an HR services that lives in the cloud, or you're going to purchase a payroll services, all right, where the prospective vendor, all right, is somewhere outside of the EEA, all right. They could be anywhere in the world. So it's important that you have a contract with them. And what that contract would do, like I said, it would clearly define, the expectation and responsibility of both parties. All right, this is very, very important. All right. So what it would do is it would kind of outline or set out, the goods and the services, that the supplier is providing, the expected, quality, the standard, the delivery schedule, I mean, all the things that you would expect would, be, called out or be detailed in that contract. All right. Clarity a lot of times will help you to reduce a lot of likelihood of misunderstanding, all right, or anything that could arise, that could lead to dispute, all right, in that relationship. All right. So, your contract would help you, to do that. All right. Someone might ask me, all right, I'm an infosec wale, or I am a GRC analyst. All right. Will I really be involved? All right, in the nitty gritty, all right, to the letters, what a contract is? No. All right, and that is absolutely no. And we're going to come back to that later. All right, legal has that responsibility. All right, they will look at the contract in details. All right, and they will call out anything that is ambiguous, that is not clear. All right, you would have a role to play, but you will not be responsible, for the entirety of that contract. You're not accountable for it. All right. You're an SME, supporting the review of the contract, but in terms of the details of the letter, it is not your responsibility. All right. The second thing that I have here, is legal protection. All right. Again, I do not mean to insult you. You know this. All right. I cited an example earlier on. If you're making a purchase, all right, the reason why you have to read your contract, properly, is just to ensure that, you protect yourself. So contract are legally binding document, all right, and they provide a framework, for resolving, all right, dispute. All right, dispute will arise. All right, but contract is there, to protect both parties. All right, so in the event of a dispute or a disagreement between two parties, or maybe a breach of terms, all right, the contract will serve as a legal reference point. All right, it would serve so. Okay, so again, I'm not going to flog that one. You know what it is. All right, but what does it mean? All right, contract is contract, or agreement is agreement. So if you, like I said, the example I cited earlier on, if you think about the agreement when you purchase that property or when you purchase that vehicle, is the same thing for your organization. When they enter into an agreement with another organization, it is legally binding. And that's why it's very, very important, all right, that it is carefully reviewed, and you know um anything that is ambiguous is called out, it is resolved before, the business would append their signature. All right. Contract could also, be used for risk mitigation. It could help, mitigate various risk that is associated with, supplier relationship. This could include maybe risk of non-performance, all right, risk of non-compliance, and we're going to get there, later on. Remember, earlier on I was talking about some of the key activity under phase 4, where I'd mentioned that one of the key activity I said, under phase 4 contract review and negotiation, I said service level agreement. All right, you can have that with your vendor. All right, and the reason why you have service level agreement is so that, you can hold them, they can be held responsible, when they are not performing. All right, when they are not performing, when they are not doing exactly what they have been they've been contracted to do. Let me give you an example. Let's say if you have a service, a service agreement, or you have a contract with, British Telecoms, and they provide your organization with internet pipeline. All right, let's say in the agreement, it says that, this internet pipeline, will be available 24 hours in a day, across 365 days. you would expect that that would be the case. All right, but where you are experiencing, intermittent connections, where you're experiencing situation, where your internet just disappear for a day and it returns the next day, you would agree with me that that is they are underperforming. All right, but if you have something in contract, all right, that clearly calls out that particular area, all right, that the services will be up, for a period of time, and then your contract can serve, as a risk mitigation if they are underperforming. All right. So you can see again that it becomes very important. Ladies and gentlemen, this is very important because you see, sometimes when you walk into an interview and you're having a conversation, all right, with hiring managers, these and many, sometimes some questions that they might ask you, and you might trip you off, if you don't know the importance. So as easy as this is, please, I want you to pay your utmost rapt attention, all right, so that the importance and why, the importance, and why contracts should be in place, before, why contracts should be carefully reviewed, before you sign them, off. All right, then we also have payment, price and payment terms. We have quality assurance. I'm not going to really go into that. We also have confidentiality and also intellectual, property. Let me just talk about confidentiality and intellectual property. You would agree with me with some services, all right. It might require that both parties exchange very, very valuable information, with each other. Most contracts these days, it would be a case of where, they are processing data, on behalf of your organization. So I cited an example earlier on. If you imagine that your organization, as is going out to procure, an HR services, maybe for 5,000 staff, okay? And so if that HR organization is external to your own organization, okay, so it's no brainer, at those 5,000 staff in your organization, you have to, as it were, exchange data, all right, with the HR, company. All right. So again, those data, depending on how sensitive they are, all right, they could be confidential depending on how you have classified those data in your organization. They could be confidential. All right. So in other words, when you contract a service out, there might be an exchange, of valuable information, sometimes intellectual, property. I don't know if you've worked in an organization or you've seen situation whereby you've contracted out a piece of work, to a software development company, to do a piece of work for you. All right, and that piece of work is maybe, you wanted to go out into the marketplace, to sell a very unique services. All right, and you need, an organization to develop, a powerful software, that will be able to service, all right, your customer. All right, so you own the idea, but you're bringing in a third party, to develop a software that would enable that idea. So that idea, all right, is an intellectual property of your own organization. So if they're going to do that, if this third party organization, which is a software development company, is going to help you develop a software that would enable your idea, you would agree with me that you need to have a very, very robust, a very, very tight, contract with them, so that what will happen if you don't have such contract. All right, they might also, run away with your idea or even share your intellectual property, as it were, with other clients. And this would take me, to a part of this conversation today, where I call contract ecosystem. I want you to hold that thought, because there I'm going to be talking about, NDA. Some of these things, you guys know them. But what I wanted to do today is just to bring it to light, so that you can see where it applies. All right, in the entire, TPRM. All right, so let's move on. I hope you can see the screen. I do apologize for all the technical glitches that people are experiencing. Is my screen still okay? I hope it's not blank.
It's okay at the moment, Wale.
Talk back.
Showing.
It's okay. All right.
Yeah.
All right.
It's
Thank you.
okay.
All right. Thank you. All right. So now we know the importance of contract. as it were, we know what an agreement is. All right, here I'm going to be talking about, all right, standard, contract and enhanced contract. All right. So I want to talk about types of contract. Okay. Um, some of you must have heard the word standard, maybe where you work, or maybe this is just new to you. You just know that contract is contract. All right. So again, standard contract, a generic agreement that follows an established legal principles and standard, firm. All right. I was speaking to Yinka yesterday, and what we're preparing, for today, and Yinka, who is a trained lawyer, and we're saying, oh, is there anything like standard contract? Do I mean do organization call it a different name? And Ginka kind of agree with me that, yeah, I mean, places that he has worked as well, the word standard contract, you will hear it being used a lot, and you would hear the word enhanced contract as well. But I'm going to be explaining what this means in the context of third party risk management as well, maybe vendor management. All right. So when we hear standard, it's different from enhanced. All right. So a typical standard one, standard contract would include just the normal terms and condition. I want you to note that, please. I don't know what interview you would end up having, but just note this. It would involve, just your normal, terms and condition, T and C. A lot of us know what T and C is. Maybe T and C for payment, maybe T and C for delivery, maybe T and C for warranty. It would just contain the basic elements. All right, this basic element, I haven't qualified it here. Just hold that thought, because further down in the slide, I would explain what that is. All right, so standard contract, is will contain, like I said, or it would include, all right, just basic terms and condition. All right, then what we have, the enhanced. So the enhanced is almost like a better version of the standard. All right, this actually goes beyond the standard, contract. It goes beyond the normal, terms and condition. All right, there's a bit of complexity. All right, that is baked in. All right, into an enhanced contract. All right, this sort of contract is often tailored, to unique requirement of parties involved. All right, and the enhanced contract, can include additional clauses. If you remember, if I take you back earlier on, I was saying that one of the things I'm going to be talking to you about today is GDPR clauses. I also said I'm going to be talking to you about, information security schedule. All right. Then we said, oh, perhaps we're also going to touch on what we call the master service agreement. All right. So in an enhanced contract, you would always have something additional, all right, just beyond the standard terms and condition. And that additional clauses could be GDPR clauses. All right. It could be information security schedule, all right, that you are baked into it. But you see, truth be told, all right, standard on an enhanced contract is driven by something. All right, that's something I'm going to be showing you in the next slide. We can see that it is different. All right, but the question you may be asking me is, Wally, all right, what informs standard contract? What informs enhanced contract? On what situation, all right, would I be using one or either of them? All right. Don't forget here that you do not own contract. All right, because I speak, most of the people, my audience today, I know most of you, your GDPR, your GRC, your cybersecurity, maybe specialist or whatever it is, you're not legal. Well, that's an assumption that I don't have a legal person here, except Yinka, all right, or maybe if Ari is here, as well. But I think the point I'm trying to make here is, all right, you wouldn't worry so much, as a GDPR analyst. Um, I, I mean, you should know, to be honest, because you should know to correct. You can correct,
Yeah.
when I say correct, in the sense that if your organization decide, to, or if a vendor, decide to, if you decide, not decide, if, based on the risk, the contract is supposed to be enhanced, but they're giving you a standard contract, then that wouldn't work. All right. Okay. You should know it actually, but the point I'm trying to make there is when it comes to ownership. all right, of the contract, it would be with the legal, department. All right. So all that thought, because we're still going to be, moving on slightly. So here in this next slide, slide number 6, I want to talk to you about, master service agreement, statement of work, non-disclosure agreement, information security schedule, and GDPR clauses. So earlier on, you heard me talk about each of this. But what does it mean? And so when I was speaking to Yinka and when we were preparing for this, I was saying to Yinka that a lot of people, if you're interviewing or if you're new to the space, when you go out there, you would normally, hear this word. They just throw it at you. But it's important for you to know, you know, when it is being used, all right, what it means, all right, and when to use them, all right, what it means and when to use them, all right. So in the next few slides, we're just going to be talking about each of these ones, all right, and hopefully maybe we can find some meaning to each of them. So number one is NDA, all right. So I'd call this slide contract ecosystem, all right. And each of this is like they would precede, one would precede the other one, all right. So we have the NDA, which is the master non-disclosure agreement. Then we have the MSA. Then we have, all right, the statement of work, all right. So what it is, I hope you can still see my screen.
Yeah, we can.
Okay, all right. Okay, I'm glad it's a little bit stable now. All right, again, you can apologize for technology, but I apologize for the
Yeah.
technical glitch. All right. Okay. So we have the non-disclosure agreement. Like I said, all of you, most of you, all right, you know what this is. All right. So it's a legally binding document as well that governs the exchange of confidential information. I want you to know the word confidential information between you and your vendor or between the third party. This would usually outline which information can and cannot be divulged, all right, to a third party. Earlier on, I cited an example where maybe your own organization, you own the idea, all right, but you're going to contract, a piece of work out to a third party organization who is a software development company. Your idea is golden. Your idea is the intellectual property. But you see, for the organization that is going to be developing the software for you, by reason of that, or by reason of the work they wanted to do for you, there are certain very important information that you will share with them. All right. I mean, a lot of us has been in this situation. All right. So for that reason, all right, the first thing first, as a matter of fact, NDA will precede a normal contract. All right. So before you write the big contract, the moment you start to have a conversation, all right, with that organization, all right, what you would put across is an NDA. The moment you know, or your organization come to the realization that you would exchange valuable, you see, whatever that your organization considered valuable, it is valuable. All right, maybe to your third party, maybe it's not very important. It might be data. If data is very important to you and you have classified it, maybe to be sensitive, okay, so whatever you consider value, the moment you are exchanging it, you're about to exchange it, then non-disclosure agreement will precede it. This is very important because you can walk into an interview and they may want to confuse you. All right, and they will give you and put the scenario down and say, oh, which one do you think? Do you write a contract first, or should you do statement of work, or should it be NDA? All right, NDA precedes. All right, and like I said, if it involves exchange of valuables, the first thing first is you have to protect your organization, and this is also legally binding as well. All right, let's look at the second one. The second one is called master service agreement. So this is master service agreement is a contract on its own. Just bear with me. All right. So master service agreement um is a form of contract which outlines the scope of relationship between two parties, including terms and conditions for current and also future activities and responsibility as well. So MSA is a massive document. All right. Some organization would have it. It's massive. It's like a so if imagine if you work for Sainsbury's, all right. Sainsbury's can have a master service agreement. All right. So it is their own form of contract that they have written. All right. So if Sainsbury's is going to engage the service of, um, let's say, Amazon, all right. Let's say Amazon is going to do some piece of work for them. Let's say they're going to be exchanging goods. Let's say HelloFresh. Some of you know what HelloFresh is. So HelloFresh is going to come from maybe from Amazon. That is going to get to Sainsbury depot all across the world. All right. So and Sainsbury has so many other company that is similar to Amazon that provide services for them. All right. So Sainsbury can say, you know what, I have my own MSA. I've drafted a contract. All right. And this contract is what I want to use to enter into an agreement with anybody, any other third party that is providing services for me. So those MSA, will contain the terms and condition that any supplier would have to fulfill, before they can engage, Sainsbury's in a service. So it is a written, predefined terms and condition, written by an organization. That organization could be your organization or Sainsbury. All right. What this usually, do is it would allow the parties, not to create a new agreement for every action between those two parties. So, in some organization, they would have, vendors. They just have, their preferred suppliers. They have people that provide services, for them, and they can have a long time relationship with them. And that relationship could span to maybe like, 15, 20 years. All right. As long as those companies are alive. All right. And as long as, the terms and conditions are good, they will continue to provide, services for each other. All right. So where that is the case, they could come up with an MSA. All right. An agreement between those two parties. All right, on how they want to work together. So it wouldn't be a case of, oh, for every time we wanted to do some piece of work together, we have to go and write a new contract. So MSA can be very, very good. But Inka, we were discussing yesterday that every time you write an MSA, it's crazy that it would always favor one company,
Yes.
against the other
Mhm.
company. All right. So where I've seen MSA, you see, often when you present an MSA to another organization, they quickly reject it. You know what I mean? So
Yeah.
it's because the terms and condition will favor where that MSA is originating from. But
Yeah.
what is the takeaway here? I want you to know that MSA is there. All right. Some organization would have it. It works for them. Okay. If you want to provide services for us, this is our terms and condition. Go read it. If you're happy with it, then we're all good. I mean, I'm not to say that MSA are not flexible, and not to
Mm.
say that MSA are stringent, all right, or quite rigid. That's not what I'm saying here. I'm just saying that often when an organization writes an MSA, it would always be in their favor. All right. So take that away. That we also have an MSA, which is a type of predefined contract, which usually outline terms and condition that will govern the relationship of two parties. All right. Then we have the statement of work. All right. Inka, what I'm going to do is I'm not going to move to the end of the slide. I'm going to flip
Okay.
back now and I'll allow you to just weigh in into some of the things that we talked about. Then
Yeah.
I'll take it from there. So, all right. So,
Okay.
be warming up for me, Inka, if that's okay. All right.
Yeah. Yeah. That's
Then we
fine.
also now have what we call, statement of work. All right. So, statement of work is a document that sums up, all right, or describe the scope of project. Okay. So let me take you back. So earlier on, we talked about, your organization that have got the golden idea. All right. You want to rule the world. As a matter of fact, you want to create something that will revolutionize the world as an idea. But you need a type of technology or software to powers, all right, to enable that idea. We said your idea, all right, is your own intellectual property. We said the first thing first, before you engage that organization, is to sign an NDA. All right. So NDA will go first. All right. Once the NDA go first, all right, then obviously you also have to define what we call the statement of work. All right, the statement of work would precede. So this is very important. You don't put a statement of work first before the NDA. You know what I mean? So NDA will go first for that
Yeah.
scenario that I've just created now. All right,
Mhm.
NDA will go first. All right, the statement of work, will now follow. All right, Yinka, we're discussing yesterday, that in some organization, if you already have like a business relationship with an existing supplier, all right. So if you are, please, this
Mm.
is another scenario. All right, if you have an existing supplier, all right, existing supplier in the sense that they do work for you, they provide services for your organization. Let me give you an example. Let's say you work for Sainsbury, and your
Mm.
existing supplier is EY, all right, or let's say your existing supplier is Deloitte, all right. So Deloitte, they do consultancy for your own organization, but they've been doing this for a very long time. As a matter of fact, they've been providing services for Sainsbury for the last 10 years. All right.
Mm.
So if there's a new piece of work, all right, that all right, EY is going to do for you, or Deloitte is going to do for Sainsbury, all right, you can look at the contract and renegotiate contract and review it, all right. But if you don't want to go to that rabbit hole of going through the contract again, what most organizations will do is where I've seen it done. Okay, all right, they will look at again, what are they doing for us? All right, are we exchanging any sensitive information with them? All right, if we're doing that, all right, do we already have an existing NDA with them? All right, if that NDA is there, then that's fine. That is still binding. All right, but this is a fresh piece of work, isn't it? They haven't done this before us. Then what would happen is you need a statement of work. So you could see this other scenario now. This other scenario just says that, listen, they're already an existing supplier. Perhaps you already have an NDA with them, all right, but they're doing a new piece of work for you. You would definitely need a statement of work. It's a document, like I said, that would describe, what that project what exactly they are delivering for you. Um, it's also legally binding as well. Yeah, all of these documents are legally binding because if they
Yeah.
fail to deliver, what has been agreed, then again, you could use the document against them, if you have to take them to court. All right. So statement of work again have to be clear, have to be concise, easy to read. All right. You could interpret it. It shouldn't be ambiguous. All right. It should be pretty much straightforward. Like I said, it leaves it leaves room for doubt
Mm.
or any ambiguity. All right. So that is statement of work for you. In the next slide, I'm just going to quickly show the comparison. Then I'll bring Inca on. All right. So this is how I've compared the three. All right. This slide is going to be available if you just wanted to know the relation. But you could find something that is common to both of them. Like in the NDA, we said here description of party involved, definition of what we call confidential, disclosure period. NDA cannot be forever, you know what I mean? All right. Confidentiality, exclusion, the time of the confidentiality. Maybe Yinka can explain a little bit more here, you know, um, and it went further there. Disclosure is very important when it comes to NDA. The MSA is different, all right. Again, the scope of services, all right. I mean, NDA, you don't talk about scope of services, all right, because you have not actually contracted anything out to them, all right. You're just only agreeing, that we'll keep our secret secret, all right. MSA would contain all of the scope of services, all right. MSA is a little bit also similar to statement of work as well. But in a statement of work, there will be scope, what is in scope and what is out of scope. All right. In MSA, you will go on to talk about the terms of the partnership. Again, how you will terminate each other's contract, how you fire each other, liability and indemnity as well will be covered under your MSA. Then under statement of work, again, you see their service description, what the project is all about, the
Yeah.
deliverable, the schedule, the payment terms as well, because now you've contracted the job. Payment had to be clearly, explicit. You know what I mean? When they're going to get paid and how they're going to get paid and all of that. All right, it will be covered under statement of work. I believe that with this explanation, you've been able to see the difference, between these three, and circumstances or situation, where they would be valid. All right. So what I'm going to do is I've got Inka here because we're we're co-presenting this one. I would go back a little bit.
Yeah.
Um, yeah, just spell me.
Are you going back to the phases? Wale.
All right. I think we should start from yeah, phases. Let's
Yeah,
say, yeah, let
yeah.
me take you back to the phases. All right. What can you see now? What is a
I'm
contract?
saying vendor
Is that correct?
contract.
Is that what you can see?
I'm saying what is a vendor contract?
Vendor contract. Yeah, what is a
Yeah,
contract, right? Is it
yeah.
vendor contract or what is a contract? What is a vendor contract? Do you want me to go to the first slide?
No, it's the first one because the
Okay.
first
All
one
right.
would
So
give
yeah,
would
so
show
yeah,
how it's being done.
Yinka.
Yeah,
I mean,
yeah, that's the one.
can you see the first one? Okay. All right.
Yeah, I
So
can see
here,
it.
I mean,
Yeah.
under phase four, that we have here, I mean, from your
Mm.
yeah, from your experience, what do you want to add? If there's
Yeah,
anything particularly that I've missed that you want to add from here that may
okay.
benefit our
Yeah,
listeners there.
okay. Yeah. Thank you, everyone. The name is Yinka Kuponi, privacy professional, sitting in the legal team. And I think you made one very, very good point, Wale, which is the expectations of a privacy professional, or let's say an infosec professional, is not to own the contract, but and I like the way you've put all these phases. So you have 1, 2, 3, 4. So what I'll do is I'll try and kind of make it practical in a real life situation. So what you'll probably find is the planning stage. It could be the business, and when I say the business, it could be an operations manager, an operations director. He's seen a product that he wants, so he's put in a request. Usually, it will be supply chain or procurement that would go and source these things. So, like for instance, in the company I work for, we have what we call an SRF, which simply means supply request form. So I'm trying to put it in the context of vendor client relationship, or you could say processor controller. So what would now happen is, okay, we've seen our preferred vendor, and as Wale said, we have a system that will do that risk classification and put it into the various tiers. What would now happen is we would get a prompt, a trigger, and that trigger, sometimes it can be like an email, and it would flag and say, oh, a high risk supplier. So the question we would ask is, why has that supplier been classed as high risk? The reason why is it could be one, they're going to be processing personal data, PII. And sometimes the PII could be special categories of data. So that's why they've been flagged. And what would now happen is, off the back of that, as Wale said, you do a due diligence questionnaire, which you'll send out to them. Could be in the form of an email, a questionnaire, or some companies, they have softwares that they send out to the suppliers. And as Wale said, it will be a combination of someone from infosec and it could be someone from legal, or it could be someone from GRC, or it could be a privacy analyst or a privacy manager, who would now go through the responses. But this is where, in an interview scenario, what because the presentation so far is showing what happens in a controlled environment. As you all know, the world isn't always like that. So what sometimes when they send you a curveball in an interview, and as what I was saying earlier, where he was saying it was very important to know the NDA, the MSA, and the statement of works, is because they won't come to you in that order. Sometimes the business will just say, oh, you're the SME, can you look at this document for me and tell us what's the next steps? So that's why Wally was saying it's so important to know, okay, what is the document trying to tell me? But if I go back to this, off the back of the whatever answers you give is what you will now feed to phase four, which is the actual contract. But what you find sometimes you'll get a contract where they'll say, oh, you're the SME. Can you look at this contract and tell us what the data protection provisions are, for instance? And then you look at the contract and say, okay, right, I've looked at this contract. I can see there are some provisions. The first thing you would do is you flag to them that, okay, has this supplier been classed as high risk? So has 3 taken place before I look at number 4 for legal? So and the way you do that is you go back to the initial, or the requester, that's what we call it in our organization. Who requested, who told you to look at this contract? Bearing in mind, it's going to sit with legal, but you have to appreciate all these departments are stretched and they're busy. So legal will get it, and it was like, has Wale looked at it, has Yinka looked at it? Because they're the SMEs. If they haven't, can you send it to them to look at? So we would get it, and then we would look at it and say, okay, right, has the due diligence been done before this has landed on my desk? So you can see the interplay between the different phases, and that's when you would now go back. Okay, it's been done. Then you would now, the same arrangement Wale was saying, that's when you will now go into that kind of arrangement. So that's what I was gonna just quickly add in a real life scenario. They don't always come in that order, but the plan is, if you can identify the order they should come out in, that's the sort of thing that will get you through in an interview. And that's why it's so important to know the different things. Again, the contract doesn't sit with you, but you'll be the SME that would look at the contract. And then sometimes you could look at the contract and there are other things that Wale has mentioned, which will be a red flag, which you will now flag to legal.
Yep.
And they'll be like, oh, okay, thanks for spotting that. We will deal with that. So that's what I was going to add, Wale. And that's why I wanted us to go back to that slide.
Okay, thank you. Thank you. Any other thing that you want to add under here, the importance of vendor contract?
Importance of the vendor contract. No, I think you've covered most of it. I think the risk mitigations, that's a key one, as you said. And I think sometimes what you find is in real life scenarios is, and I think we spoke about this yesterday, which is to know the key difference. In this relationship, are we the controller
or the processor?
Or are we the processor? Yeah. It's very, very important. You have to, because sometimes these contracts, sometimes they come to you wishy-washy, sometimes they're not clear. And then you start looking at the contract. Okay, so if I'm a processor, or I'm looking at it now as a vendor, I would look at the contract, and as Wale was saying, whoever hands the contract in, it's always going to be favorable to them. So our job is look at the necessary provisions you need to look out for. The data protection, I'll use the word data protection rather than GDPR. So the data protection provisions are those are the key things you'll be looking out for. So, where we look at Article 24, which is for controllers, Article 28 for processor, you would look at that and say, okay, right. Oh, in fact, I dealt with one the other day where I had a contract. Say, oh, can you review this contract for us? It's a vendor contract. Okay, so why didn't we, as the controller, why didn't we give the vendor our contract? Or it's one of those, because sometimes what you find is large vendors like the Amazons of this world, and that feeds into what Wale, when you were talking about standard contracts and enhanced contracts, what you find with large vendors is they haven't got time to go into a one-to-one relationship with you. So they'll just say, here's our standard contract, deal with it. If you're not happy, move on. Because they're so big, they're not concerned with the finer details. So what you will find is, in that kind of scenario, I had something like that land on my desk, and I looked and I said, there's no data protection provisions in this contract. Oh, really? Yeah. So that goes straight back to the supplier, and that's where all the negotiation starts. So that's why it's key to be able to spot these things, and that's what you were highlighting. Yeah.
Yeah. Thank you.
That's okay.
Yeah, we've talked about this one.
Yeah, we've talked
anything that you wanted to talk about, NDA, MSA, and statement of work?
Yeah, NDA, you were right with the NDA, which is in terms of, it's usually, as you said, it's to protect. So, as you were saying, again, I've had scenarios like that before where the business will come to you and say, oh, there's this new piece of software that we like, so we want to go into a temporary arrangement with the supplier to use that piece of software. So it means at the end of the temporary arrangement, you may sign me on as a client, and at the same time, you may not. So they would send you a non-disclosure agreement, which means once you've used our tool or our software, you won't go and disclose it elsewhere. And that's why we have these non-disclosure agreements that Wally was saying. And if at the end of the temporary arrangement, we now decide, okay, we're now going to use you, then you can go into the full one. And that's where you now have your MSA, your statement of works, and all the rest of it. That's one example I can use for that one. Statement of works, I think you were correct with that one, where you're talking about where the supplier would provide all the services, what's going to be included in the works. In fact, one very interesting one I usually find is where there'll be a clause that would say the supplier will allocate sufficient resources to provide the services in accordance with this agreement. Because sometimes what you find is some third-party vendors are so busy trying to source for more clients, they're not allocating enough resources to the service, and that's where it could be a breach of the contract, or they could lead to disputes. So these are all the kind of red flags that one needs to spot out for. But it's just to show how all of them are interwoven. Yeah, so that's something I wanted to add to that one as well.
All right. Thank you. All right.
Yeah,
So thank you, Yinka.
yeah.
So guys, if you have any questions, just
I think, sorry, Wally, there was one other thing I was going to just quickly. You know, when you made
okay,
the
yeah, go
comparison,
on.
that's slide, I think it's 11. Yes.
11.
NDA,
Yeah.
MSA, and statement of work. I think another thing that comes up a lot is where we have liabilities and
Liabilities.
liability
Yeah. Mm.
indemnification. Now, you made one very valid point at the beginning where you said this would sit with legal, and it would do. So it's not the job of the privacy
Infosec.
professional
Mm.
yet or infosec, but because you've done a few of these things, you now get an agreement or a contract, and it says things like uncapped liability. That's a red flag, because
Mm.
what you're trying to say is you're not capping in the event of a breach or a dispute. You're saying you're not capping what I'm going to be owing. So usually there's always has to be a cap. Find is the controller who's dealing with their supplier or a processor. They would say things like, in the event of a breach, or in the event of a breach of the agreement from you, the vendor, we're going to uncap the liability. So what you'll find is that the processor would counteract that. This is part of the negotiation and say, no, we need to cap it, because real life happens. Things can happen. If you make it unlimited, then you're going to put us out of business. So we're not saying you would be the ones that will be dealing with that, but these are just things where if you flag them, these are wins. You know, terms of determination, when you look at NDAs, confidentiality, exclusion, it's just all these key words that one can look out for. Yeah, that's what I was going to say. Thanks.
All right. Thank you for that. So we'll continue. I'm conscious of time. So
Yeah,
Inka, great
yeah,
analysis. Thank you. I'm going to be talking about information security schedule. Then I will now move on to contract clauses. So Inka, be on a standby because I want you to talk about SEC, which is the standard contractual clauses. All right.
yeah,
So what is information security schedule? All right. Um, it's so it's important that I quickly say this that depending on where you work, here in the UK, if you work for government, you would always find something around schedule. Government like this schedule. All right. So if you work for local authority, you work for likes of maybe Department of Works and Pension, maybe HMRC, you work for all the public services, you will come across, the word schedule. All right. So they would have what we call information security schedule. Though if you do go to, private parastatals as well, banks, you might come across where they said they have information security schedules. If they don't call it information security schedule, they may call it standard. All right. Please, it's important. But it means the same thing. Okay. It means that organization, you know they it refers to planned set of activity. It refers to like a task. It refers to, event relating to securing information and data. All right. It could be part of a broader information security management system, which is ISMS or cybersecurity program. So where you work, you will say you might hear the word, oh, our information security standard or our information security schedule. All right. So what they've done was that organization, they put together, or like a collection, all right, of different domains or information security control. All right, they list them together and they now call them, all right, or they call it information security schedule. So in a typical schedule, you could find what we call access control. All right, in a typical schedule, you could find something we call um, encryption. All right, in a typical schedule, you could find something around network security. All right, so they would have a schedule which is a collections of different, all right, different aspect of security control. All right, like the example that I cited now. And what you're saying in a nutshell is, if you are processing our data, or if you're going to do any piece of work for us, all right, then you must abide, by this schedule. You must abide by this list of control. Let me give you an example. Let's say if you're going to, provide the services where, it will require that someone would authenticate, maybe into a software. All right. All right, the organization can tell you that, listen, we have a standard way, whereby we authenticate into our system, and it is covered in our schedule. So they can refer you to the access control, all right, within their schedule. They could even refer you, all right, maybe to another aspect of it. If you're going to, protect or encrypt our data, we have a schedule that covers encryption, and our encryption in our own organization, for every time that you're taking our data, both in transit and rest, it must be encrypted. If it's at rest, it must be 256, bits, which is the advanced encryption standard 256. So they would have that all documented. In other words, they are telling you that this is the way we would protect our information, our data, which is documented in our schedule. So therefore, if you're going to provide any services for us that will require you, processing our data, in transit and address, then you must abide by the schedule. So the schedule can be is a compilation of controls. All right. So, like I said, in some organization, they could call it standard. All right. It's the compilation of our own controls. And if you're going to provide service for us, you must abide, all right, by this schedule. All right. So hold that thought. Schedule is different from information security schedule is different from GDPR clauses. All right. So GDPR clauses, I've listed a few here. It just focuses, of course, GDPR, all the clauses, that I'm talking about here, is an extraction, from GDPR. Some of you have been trained on GDPR. And if you think about GDPR, if you think about GDPR, you would have clauses around data protection clauses, sub-processing clauses, data security clauses, data breach notification, data notice period, audit clauses, international data transfer, duration of processing. All right. So there are about how many of them here? We've got about 8 of them. But you see, each of these, all right, they are extract from GDPR. All right. So organization can take this extract and call it their own clauses. All right. So in other words, if a vendor is going to provide a piece of services, for them, or they're going to provide a services for them, you could take out of these clauses and embed it into the contract. Let me give you an example. Let's say, an organization is going to provide a data processing services for you. The example that I cited earlier on, whereby you are contracting out the entirety of your HR service to a third party. What we have established earlier on, we said that because you're doing that, there will be data exchange. So if your organization is about 5,000 staff, that HR organization that is providing the services, they would have access, all right, to those data. All right. So because of that, if you decide to go ahead and enter into a contract with them, guess what you would do? Baked in into the contract, you could bake in breach notification. So in other words, if that HR company suffer a cyber attack, for example, maybe whether it is intentional or maybe by reason of negligence, all right, if this clause, which is breach notification, is in the contract, then they are obliged, by the spirit of that, contract, to let you know, when they suffer, data, when they suffer, maybe a cyber attack that could lead to data breach. All right. Again, if that HR company is outside of the EEA, let's say, they're in South Africa, and your organization is here in the UK, guess what? Again, you could baked in, all right, into that contract, international data transfer clause. All right. As a matter of fact, they don't need to be outside of the EEA. All right. You could also put it in the clause here. We're giving you a lot of information, 5,000, employee record. So therefore, we have baked in a clause into that contract to say that under no circumstances should you transfer our data outside of the EEA without an express consent
Consent.
from our organization. All right, you could even bake in another clause there to say that, all right, HR company, all right, under no circumstances should take our data and give it to a third party, a sub processor. You're not saying that you could have so many sub processors that is doing work for you. Like HR service, you could imagine that HR services or HR company, they will not be the one building their website. All right. If they have a
Yes.
piece of software, that they use for their HR business, it's not built by them, it's built by a third party. All right. So
Yeah.
again, you're conscious, to bake into that contract a clause that says that no sub processing. You are not authorized or allowed, to take this 5,000 record of our employee, and share it with another person. All right. So before I bring um because Yinka is really excited to talk about this particular area. Before Yinka come in and talk about this particular area, let me quickly now, earlier I was talking about information security schedule. All right. So under information security schedule, what is listed there is mostly different from GDPR contract. All right, you could see here, you could see data processing clause, sub processor, data security, access, bridge notification, notice period. All these clauses are in a typical, you know, um, IS, information security, schedule. You would have things around access control. You could have things around, data encryption. You know what I mean? Though GDPR also talks about data security as well. It didn't quite go. It makes it open. It didn't go into details. But in an IS, information security schedule, it just goes straight and says this is data. Encryption. So, Inka, do you quickly want to talk about anything here that you think might be interesting,
Yeah, yeah,
that you want to share with the student?
yeah. A couple of things I could quickly talk about, because you mentioned SCC and international data transfer clauses. So simply, what we're talking about here is transfer mechanisms. When you're
Yep.
when you're sharing data with a country that's classed as a third country, which simply means they haven't been given adequacy because they haven't got the appropriate safeguards. And SCC, which is simply standard contractual clauses, it's a set of clauses which sometimes, as Wale said, it could be embedded into the contract. So as a GRC or more, this will pertain more to a privacy professional or a privacy analyst. Your job will be
Mm,
like, okay,
mm,
we're gonna be sharing this data with a third party that's maybe, let's say, based in China. And then you've gone through the whole
yep.
thing. There's a clause that talks about international data transfer, but it was just a one-liner. So that's a red flag. Where's the
Mm,
standard contractual clause? And that standard contractual clause is a body of clauses. Sometimes it's, what I find from my experience is it's mostly always embedded into the contract. Your job is not to go through the finer points. Your job is just to recognize, is it there or is it not? And now,
mm,
because of Brexit, and now that we've left the EU, what you're now finding is we have what we now call the UK IDTA, which is United Kingdom. Um, my brain has gone blank now. International Data Transfer Agreement. So what you'll find is it's sort of like you have that, and you also have the UK addendum. Again, you can find there's a lot of because of time, there's a lot of about it on the ICO's website. And what you find is, so rather than use SCCs, that's what's being used now in place of that. So that's one key thing I was going to point out there. So again, it's being able to identify that within the contract, especially when you have vendor contracts, because sometimes, as Wale said, you might share data with a country in China, but then the support personnel or the support team could be in India. So you can see
mm,
automatically that's spreading to three different countries on three different continents. So that's why it's very important for that. Another good one is sub-processing clause. And what I tend to find from my experiences in vendor relationships or vendor contracts, what you tend to find is the sub processor is always silent. Now, if you remember when
Mm,
I said you need to understand the position of the controller, the processor, but then you also have the sub processor. These are key GDPR terms. And what you find is I have a relationship with a vendor who's going to supply me with services, but the vendor has failed to mention that there are other third parties that are also part of the chain who will be providing this service. So again, you'll be looking at that. Is there another party to this agreement that is helping the vendor to provide the service to us? So if there is, it's just a case of them. Sometimes it's a one-liner to say, as Wale was saying earlier, under no circumstances do you onboard a new third party without making me aware, and it has to be written, expressly written. Another very good one is the audit clause. Now the question
mm,
is, so what does the audit clause mean in the contract? Sometimes the controller would put a clause in there to say, you as the vendor, I have the right to come onto your premises to audit um, the way you're providing us with the service. And sometimes some vendors will push back against that because maybe they've put their they can just come without notice. So sometimes the vendor would say, we want notice before you come. So those are some of the key things. Then there's a breach notification clause. That's another one that you tend to find in contracts where sometimes vendors would put in there that over a 48-hour period. So then the question now comes, so you're saying you would notify me of a breach over 48 hours, but that's not giving me enough time as a
time.
controller
Mm,
to report that breach. So that's where negotiations will come in, where they would say, okay, you need to change that to 24 hours. Because if you tell me in 24 hours, then you're giving me 48 hours to decide, does this meet the threshold for me to report the breach?
yeah.
And again, you as a privacy analyst or privacy manager, you won't be involved in the negotiation, but your job is to flag it. Sometimes you flag it to legal and say you are aware that you have to notify the ICO within 72 hours if the breach meets the threshold for reporting. And sometimes we're not saying the breach is the fault of the vendor. What we're saying is, once the vendor becomes aware of a breach, you need to notify me without undue delay. And sometimes
Yeah.
they start going back and forth over the timing, because sometimes the vendor wants enough time to be able to decide, okay, do I need to report this to the client or not? But the
Not.
client is not
Mm,
interested in that. You tell me straight away, and then I can go and deal with it. So it's just being able to pinpoint all these key clauses in a contract. Yeah.
absolutely. Thank you. All right. So we'll move on to the next slide now. Just very conscious of time. So bear with us. There'll be opportunity to ask questions. Just bear with me. I'm going to run through what we have next, and we'll be done. Maybe in the next few minutes. Thank you, Inka, for that. Here, I want to talk about vendor risk and the type of contract. If you remember earlier when I said there are three, we talked about two types of contract. I didn't answer the question what actually would inform the type of contract that would be chosen. I said there is a standard contract, then we also have what we call enhanced contract. So what I didn't tell you earlier on is what I wanted to show you now. All right. So you remember that we said that when you carry out in the early stage of the TPRM vendor management, relationship, that in the early stage you carry out or you calculate what we call the inherent risk. All right, and we said that the outcome of your inherent risk could mean that that the relationship with the vendor is high risk. Okay, so let's say that is an high risk vendor. We said that after that you've done the inherent risk calculation, what would follow, would be usual. You will carry out a due diligence on them. And we said that what do you do when you carry out the due diligence? You prepare a set of questionnaire, you send it to them, they reply back to it with the evidences, you review it, then you will generate a report. All right. So let's assume that this vendor in question is high risk and you've done the due diligence. So often, all right, what will usually happen is the sort of contract that you would have with a high risk vendor is what we call enhanced contract. So this type of contract is where it goes beyond the terms and condition, where you would have example of the clauses that we talked about now, both GDPR clauses and also information security scheduled baked into the contract. All right. But you see, you can't have a flat contract. Yinka was saying something earlier on that often when a contract is sent, okay, you have to critically, of course, look at it. Legal would do that, all right, with the help of the SMEs. But the focus, would be usually the area of risk. Okay, so let me give you an example. We said earlier on that if your organization, for example, wanted to purchase an internet pipeline, all right, from BT, all right, you would agree with me that what will be very, very important to your organization is the availability of that internet pipeline. Is that correct? If you're mute, is that correct? Is that correct?
Sorry, Wale, is that a question to me or is it
Yeah,
you're putting?
I mean, to everybody,
Oh, sorry.
without, I mean, it would be correct, isn't it? That the
Yeah,
availability, will be very, very important to you,
yeah,
all right, of that service, all right, because internet is the internet, you know what I mean? You want
yeah,
to be able to access your services, you want to be able to get onto your server wherever they are, whether they're in a data center, you want your staff, should be, there shouldn't be any internet issues, all right, because BT is providing you the pipeline. All right. So let's assume that by reason of the services that BT is providing for you, they have come out as high risk vendor. All right. The contract that you're going to have with them, let's say, is going to be an enhanced contract. You would also agree with me that what you would be really, really interested in about that contract would be that full, among other things, would be how you're going to protect your organization, such that BT is providing, you know that services. So you're going to tie them, to a very strict SLA, because availability is important, isn't it?
yeah,
All right, you're going to tie them to a very strict SLA. The performance of that internet pipeline becomes very, very important to you. All right, so you're going to ensure that availability becomes something, among other things that will be in the contract, will be an area that you want to ensure that it is critically looked at and your organization is protected. On the other way, if on the other hand, we cited an example of an HR company. All right, HR company providing services to you. We said that data is going to be leaving your organization to go to the HR company. All right, because they need it to provide services for your employee. All right, you could see here that data is involved. All right, you see again, it's no brainer. All right, if they have come out as an high risk vendor, guess what? You see, all of the clauses that we mentioned earlier on, including clauses of sub-processing, including clauses of data breach notification, including clauses of data, data notice period,
yeah,
including clauses of data security clauses, all of that, all right, would be baked into the contract. Do you know why? Because data is involved, and data is very, very important.
yeah,
Is this making sense to us? So the point I'm trying to make here is you would always find a flat contract that comprises of so many things, but it is important for you to always tie your contract back to the area of the risk. Don't forget that we said that one of the importance of contract is risk mitigation. So your contract should be mitigating your risk. And guess what? Where you would identify the risk is when you have carried out the inherent risk calculation and the outcome of your due diligence. You would have understand, the strength of the vendor, the areas that they are weak in. All right. Those areas where they are strengthened or weak in, you want to make sure that you're covered, you're protecting your organization. In other words, all right, the type of your contract would be informed, all right, by the outcome of your risk assessment. All right, so it is risk based driven. So the point I'm trying to make there is, rather than having every contract that contains everything, all right, contract can be so straight, clear, but again, it can also be risk, based driven. Is this making sense? I know everybody cannot talk back to me, but Yinka, it makes
yeah.
sense, right?
It makes a lot of sense because what you find is sometimes what one organization classes at risk, the vendor may not class it as at risk.
Absolutely,
And the reason for that
absolutely,
is because they may not have all the right security measures that they have in place. So as you said, it is the analyst's job to pinpoint those risks. Sometimes if you put the risk to the business and the business still insists they're going with that vendor, then that's what goes into the risk
That's
register.
absolutely,
Yeah,
absolutely. So
yeah.
I'm glad that you brought that up. So
Okay.
I've been in situation where you know it was clear that this
Yeah,
is a risky relationship. I'm
yeah,
telling you,
yeah.
it was clear. Like InfoSec was telling them that listen, it's like you're going around the rabbit hole.
Hmm.
This vendor, they do not have anything. Guess what? They said they want to go ahead.
Yeah, yeah, yes,
The contract owner said, listen, in a way, it's like InfoSec, you make a recommendation
yeah,
of other organization that I mean, man,
yeah,
their control they looks okay, but they say they want someone else. So
yeah,
and
yeah,
when the contract owner decide against your recommendation, no problem. Just make sure that they're able to accept the risk and the
yes,
contract is also there, to protect your organization as well.
yeah,
So what we're
absolutely.
saying here, ladies and gentlemen, you won't always find it easy. You know what I mean?
No,
You would always get situation where even when it is obvious, that the risk is there, well, sometimes business will say they want to go ahead. All right.
that's correct.
So the second one is medium risk. So often when you have medium risk situation or medium risk vendor, all right, instead of enhanced contract, you could, use a standard contract.
Contract.
All right, a standard contract, which is, largely terms and condition, maybe a bit and piece, all right, of, GDPR or
Yeah,
information security scheduled
mhm,
baked into it. But the point we're trying to make here is, all right, enhanced contract is more stringent, it is more robust, it
yeah,
contains a whole lot of, additions, compared to, standard contract. Then lastly, we have what we call the low risk. In some low risk situation, we just extend what we call a light contract. Light contract can just be basic, terms and condition, nothing more. You know what I mean?
yeah,
It's not. Let me give you an example. If you have a vendor and the vendor they are supplier of security guard, physical security guard,
mm,
or they just supply you toiletries. All right, it is they have vendor. You know what I mean? Or they just come, they deliver, toiletries and off they go. All right, it would take the cleaner to take the toiletries, the tissue papers, and put them in the right location. They don't even access your office. They just drop it and off they go. And they do that quite often. They are
mhm,
a vendor, but their risk is low. All right. So in such situation, they are low risk. What you could just have with them is just basic, very easy, nothing less, light contract that doesn't have any complexity. As a matter of fact, you can't lump enhanced contract over to a low risk value. They will push back. What is this? You know what I mean?
yes, yeah,
Don't forget that contract or agreement they are legally binding. The moment someone signs it,
yeah,
in other words, you're saying that you would adhere, all right, to the terms and to the conditions of that
that's
contract.
correct.
All right, Inka, is there anything you quickly want to add here before I move on to the next one?
No, no, you can move on to the next one. That's fine.
All right, thank you. So we're coming towards the end. Please, your questions, we'll finish in the next few minutes. All right. So the next two slides, what I wanted to show you now is, so I'm taking the outcome of a due diligence, all right, then, and I'm now comparing it to contract negotiation. These are just random scenarios. All right. So I imagine that you have carried out the due diligence, all right, but then what should be in your contract? How should you negotiate your contract? All right. Let's say, maybe, Yinka, you carried out a due diligence for your customers. All right.
Yeah,
And,
mhm,
don't forget that when we say we carried out that diligence, we will normally find something, isn't it? There will be findings,
yeah,
there will be control gaps that you have identified.
that's
There
correct.
will be things that is not right about them. You've jotted them. They are control gaps that could lead to a risk. You know what I mean? A
Yeah,
typical example is it might just be that, oh, their privacy notice is not good. They're not
that's
telling
correct.
us about, oh, there is no, I can't see a DSAR. There is no data
Yeah,
subject access right, procedure here. So how do we,
yes,
like the case of the HR, for example, you've contracted out, all right, that job to HR, 5,000 record is going to them. Someone from your organization can say, you know what, I want to exercise my right.
that's
So you
correct.
might be that when you carried out the due diligence against the HR company, they don't even have anything in place. So it
Yeah,
means that's a risk. You know what I
yeah,
mean? That's
yeah,
a control gap that could lead to a risk. Okay. So when you identify, ladies and gentlemen, it's important I quickly say this. When you say you find something in your due diligence, maybe a control gap that could lead to risk, it doesn't necessarily mean that you won't do contract, with that organization. All right, no. It's not. In some organizations, it's not like a red flag. It's a red flag, but it's not like a no.
Yeah.
It's a red flag. Your own responsibility is to call that out to the business and let them know what is not working. But the business could make a decision, all right, for themselves and say, you know what, irrespective of the findings, okay, we can accept the risk, we could live with it. Or they could even have, if I've seen a situation where they go ahead with the
Yeah.
gaps that you have identified, they will
Yeah.
now take that gap and introduce it into the clause and said, on that post go live or after 1 year cycle of this relationship, you
Yeah.
must have fixed this issue.
That
So
is correct.
they can go ahead with that condition. They can
Hmm.
say, oh, we'll review this in 1 year. In 1 year, if you don't fix it, we'll terminate your contract. So they
Yeah.
can take all of those control, gaps back and bake it into the contract, tie the hands of the supplier and say, fix this issue within a
Yeah.
period of time. If you do not, we take our job
Yeah.
somewhere. So
In fact,
it's
Wale,
important that
can
I
I
let you
just
know.
quickly
Yeah, please.
interject? Sorry to interrupt you there. You made a very good point when you talked about human resources. We're going to be
Hmm.
sharing all this data with you, and we haven't even got a privacy policy in place. And you mentioned DISA earlier. What's been happening is people are now, I mean, the GDPR has been around now for over 5 years. People are now
Yeah,
becoming more aware of their rights.
yeah.
So, and that's why, as you rightly said, it's so important to be spotting all these red flags, which you escalate. Because what would happen is if there was 3 or 4 DSARs, they'd be like, so who looked at this contract, or who was the SME that reviewed this contract? It would be on you, because that means you
Mm,
didn't do sufficient due diligence. And you even
mm,
find scenarios where sometimes there isn't even a contract. So you've gone through the due diligence, and and I see that a lot. You've noticed a number of red flags which you've escalated, and then they'll be, okay, so is there is there an initial agreement, or is there a contract? And then they'll turn around and say, oh, we haven't got one. Then that's a red flag.
mm.
So
That's
your
a red flag.
role is to identify risk, and I think you
Yeah.
mentioned that earlier, Wale. Yeah, that's what
Hmm.
I thought I'd quickly add.
Yeah, thank you, Yinka. So it's important, please. Your takeaway here is when you walk into that interview, all right, you know, you're there to advise, all right. It's more of an advisory role, all right. The owner of the contract will they are there to make the call, all right.
Yes.
And like I said earlier on, that if when you have identified it, legal can now take all of those findings, make sure that they have a way of writing it into the contract, and they can force the vendor, all right, to put measures in place, except in a really, really, you know, if you work in an organization where they are quite risk averse, you know what I mean?
Mm.
Their risk tolerance is zero. Okay, they can't take such risk. They will drop the vendor there and there. All
Mm.
right, they can't go ahead. All right, so it might just be maybe the worth of the contract or what is at stake is high, if you know what I mean. All right,
Yeah.
they if it's a government project, for it, so you can imagine a government. Let's say you're sharing very sensitive information with them. All right, when I say sensitive information, maybe or information that we call restricted. All
Hmm.
right, and they don't have certain controls. Is a no. They will just walk away.
Hmm.
They will just walk away because the risk is high, because if anything goes wrong, heads will roll. Somebody can go to jail, somebody can lose their job, and on all of that. All right. So, but in some situation, where risk is a little bit more relaxed, they can accept it, take it back into the contract, and blah 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 blah. All right. So let's look at different scenarios. I'll call them out. I'll put my cursor here where I have the black letters here. All right, or the letters are just colored black. All right, so that is the findings from the due diligence. Please take note here. This is very important. You can use it in your own interview. All right, and this is what you will look out for. All right, in an agreement, because you see, interview is all about examples. All right, it's all about examples. That's what's important. All right, so we said risk assessment. We said due diligence reveal potential risk associated with the vendor, such as financial instability, all right, security vulnerabilities, and regulatory compliance issues. So what we're saying here is you have carried out the due diligence. The findings actually reveals all of this in your findings. All right. So how do you address that in a contract or in an agreement? We said here, we said the agreement might include specific clauses or requirement to mitigate identify risk, such as financial guarantee. You can see there. So when you say they are financially unstable, it means that maybe the worth of the contract is a lot. All right. And maybe their books are not good. When you say they don't have money, they might run away with the money. So financial guarantee is they may have to go and get a shorty. Do you understand? Or get a loan, or get another organization that will back them up. I don't know if you've been in that situation. I've worked in a big contract before, whereby maybe by nature of what will be involved, maybe it's rolling into billions of dollars or pounds. All right, you can't afford to take such money and give it to a company which is already bankrupt. They will run away with it. All right, so financial guarantee could be something that you want to bake into the contract. Security measures could be anything. It could be encryption, it could be access control, or adherence to specific compliance standard. And that adherence to specific compliance standard could be, GDPR. All right, it could be any other, standard depending on the jurisdiction. All right. The second one is service level agreement. We said the vendor due diligence again. Here it reveals or provide insight into the vendor's capability and performance history. When you say you do due diligence, you're searching, you're finding out what are people saying about them. Have they done a similar service for another organization? Is their record really, really poor? And let's say that is the case. Something came out on the back of that. All right. How can you mitigate that through your agreement? We said SLA must be adjusted based on the vendor track record and capability. You can see now that we're tying SLA to performance, which I mentioned earlier on, ensuring that service provided meets the organization standard and requirement. As a matter of fact, what you could also have here, Yinka, is
Yeah,
KPIs.
that's right.
You could have your key indicator, a key performance indicator, tie back, to the contract. Again, to just make sure that you are protected. Let's look at the third one, data security privacy. We said again, due diligence to review weakness, all right, in the vendor's data security and privacy practices. All right. Again, the vendor agreement may include more robust provision to protect sensitive information. So again, specific requirement for data handling, encryption, compliance with privacy regulation may be added to the agreement to
In fact,
address
while I can give
any
one quick
identified gap.
example, I can give one
Go
quick
for it, May.
example for that one. Yeah. So sometimes when you're looking at due diligence questionnaires, so
Mhm.
you've asked the vendor a question and say, in the last 5 years, have you ever
Have you suffered
experienced
cyber
breach?
attack?
Yeah, yeah, or an incident. So that's a very high level statement. Many would say
Yeah.
no, and you'll be
No.
thinking, okay, that's a red flag. But then you might even go into because you're thinking, do you mean to tell me? And if you notice, the question simply said, have you experienced an incident, a privacy incident,
Incident.
or a security incident? And they said no. So that's a red flag because you
That's a
mean
red
over
flag
the last
because
5 years.
everybody would
That's
have
right.
experienced
Yeah.
one.
So if you look at that question, differentiate it from the next question, which is you would look at the question and it would say it would be more specific. It would say things like, in the last 5 years, have you had to report
Quartz.
yourselves to
Yeah.
the ICO? Has any
ICO.
of your incidents met the threshold? So it's just being able to identify. So if you look at both of them, so if you look at the second scenario I gave, if the answer is
Yeah.
yes, you're not saying we're not going to work with them. What your next question will be like, okay, can you explain? So if you
Yeah.
hear things like they said, okay, we had the incident, but we contained it, and we
Yeah.
had a report back from the ICO saying
Yeah.
they're not taking the matter
That
any
but
further.
for that. And
So
yeah.
that gives you assurance. But if there's
Assurance. Yeah.
yes, but if you said, can you provide more details, and there's no answer, that's a red flag. So
Yeah.
these are the kind of real world scenarios you'll be getting, and
Absolutely.
you need
And
to be aware.
Yinka, to also add to what you just said now,
Yeah.
the good thing about the world that we live in and the internet doesn't lie. You know what I mean?
Yes, that's true. That's true.
So
That's true.
the good thing about now is, whenever any organization suffer any cyber attack, it's usually in the wild. I don't know
Yeah.
if you saw something today. There was I updated my my iPhone because there
Right.
was a
Okay.
0-day exploit
Wow.
that was reported. I don't know whether
Yes.
it was directly from Apple or maybe it was just in the
I heard
wild.
about that one.
But
Yeah,
they push a patch or a
they did.
notification,
Yes, they
and
pushed the
yeah,
patch.
all right.
Yes.
So the point I'm trying to make there is a lot of this information is out in the wild. There
Yeah.
was one due diligence that we did. It was a follow-up question to
Okay.
the response to the question that
Right.
to the response that a vendor provided.
Yeah.
And so we asked them if they suffer a cyber attack. They said no.
Okay.
So further down, the one question that we asked, which was technical, we said, "Do you use cloud?" They said yes. They now told us the cloud that they use. Meanwhile, a few years ago,
That
that
cloud.
particular
That
cloud,
cloud provider.
yeah,
Yeah.
it
Yeah.
was all
Yeah.
over.
Yeah.
So it's either they are lying or they don't even know,
Yeah.
you know, how to
Yes.
answer that question. So we now went back.
Yes.
We went to the internet, copied that particular thing, and sent it to the vendor. I
Hmm.
said, "Do you
Wow.
not know that they suffered this attack at so time?" Oh, he said they were not aware. So we just laughed.
Yeah.
All right. Yeah. So I hope you guys, you're enjoying this. So let's look at this other one. So another again, outcome of a due diligence. We said the vendor due diligence often assess the vendor compliance with relevant laws and regulations. So if any non-compliance issue were identified, let's say compliance issue, like in the case of, they were not complying to GDPR as you would
Yeah.
expect, then the
Hmm.
vendor agreement, again, may include explicit clauses like we talked about earlier on. It could be sub processor clauses. It could be a bridge notification. It could be bridge notice period. It could be data security clauses. All right, all of that, okay, can be baked into the contract.
There's
All
even
right,
something
information.
else.
Go on.
I was going to say, Wale, with
Mhm.
that, the compliance requirements. Sometimes I've seen contracts where they would say, the relevant UK laws are applicable, and we also
Mhm.
adhere to the Data Protection Act of 1998. So that's a red flag. These are it's a very simple point, but I've seen it before.
Point. Yeah.
But it's something where if you miss it, and then it's legal that picks it up, or maybe one of the operations directors picks it up, that puts you into question. Go like, what? So you mean you didn't even see when they were giving their background of the parties and the definitions and interpretations and applicable laws? You mean you didn't see that they've got the Data Protection Act of 1998 here instead of the Data
The
Protection Act of
GDPR.
2018 or the GDPR? So it's things, yeah.
Yeah, I
So it's
know.
things like that that you
Like
have to
that.
always
All
be
right.
picking up. Yeah.
All right. So the next one, vendor due diligence can provide insight into vendor capability network monitoring. All right, and also
Yeah.
access control as well. So it could be that they don't have good network monitoring in place, like a SIM, which is the security event event management. It could be that they don't have I mean normal vendor monitoring capability. All the gadget like IDS and IPSs. All right, that is not there. Access control isn't great. Again, you could adjust your contract, all right, to include or to bake in information security requirement or clauses. Then lastly, here we have audit right, due diligence review, concerns about the vendor operations and compliance. Again, organization may seek enhanced audit right in the vendor agreement. Sometimes audit right could also be driven by the nature of the services as well. If the contract is of a very, very high value, high profile contract, or maybe by reason of the information that you're sharing with each other, if they're very, very sensitive, then you would always find audit right. But to let you know that audit right is not easy. All right.
No, it's not.
To get audit right maybe with your processor, it's usually sweat and blood. All right. Because the moment that goes in there, all right, for them is an additional cost. Given that every time you want to do that once in a year. When I say additional cost on resource, they have to get ready. So you can imagine if they have like 10 vendors that have got an audit right on them. Wow. So it's a lot of work. All right. So most relationship they will push back, except if that contract is worth that amount. You know what I mean? It's a lot of money to them. They can't afford to lose that contract. All right. They may bend over. Or sometimes, I've even seen some contract, Inca, whereby
Yeah.
the audit you will the organization will pay for the audit. They
Yes.
can agree to you to come and audit them,
That is
but
true.
you
I've seen
would,
that before
yeah,
as well.
you
Yeah.
you will pay for that. You will pay for that audit. And
Yeah.
again, a lot of negotiation usually goes on, as long as both parties agreed on how they want to work together. All right,
Yeah.
the next slide is what to look for in vendor contract or agreement from GDPR or information security standpoint. I have a few here, and this is where we'll close the curtain for tonight. There are things that we've already talked about. There's just a list: GDPR requirement and obligations. What do you look for? Data processing terms and condition. You look for data protection responsibilities. It's very, very important. Yinka, I think we're a little bit silent here.
Yeah.
Responsibility of both parties
Yeah.
is very, very important. Who is doing what? All right. So
Yeah.
if you're contracting a piece of work out, all right, you would expect that maybe your data processor, so the bit around notifying us about breach, telling us about what is
Yeah.
happening, all of that, all right, would be the responsibility of the processor. But it's
Yeah.
important that you clearly, all right,
Yes.
it's clearly stated in the contract. Of course, security measures, they are important. Data subject right, we talked about that. Especially if you're exchanging data or if there's data exchange, all right, the data subject must be able to exercise
Then,
their
yeah.
right.
Yeah.
Sub-processing clause, data breach notification, we talked about it.
Mhm.
We said, again, GDPR, there's a lot of emphasis there. GDPR did talked about 72 hours reporting back to ICO,
Yeah.
but this is negotiable. I like the example that Yinka gave earlier on. And
Yeah.
in real world, let me tell you, you wouldn't even get 24 hours. You wouldn't
No.
get 48 hours.
No.
It's practically impossible. They will push back. Vendors will say, no, I can't do this. You know
Yeah.
what I mean?
Yeah.
Because they know the implication of agreeing to things like that. All right.
Absolutely.
Breach notification, we talked about transfer mechanism. All right. We talked about audit and inspection, duration and termination, liability and indemnity, which Inca covered, update and changes as well. Then under the, if you think about, information security, all right, you would have data classification. All right. So GDPR doesn't talk about data classification. GDPR just only says that there's the standard PI, and we also have special category of data. But you would agree with me that when you go into your own organization, you would have how you have classified your data. In some organization, they would have some data they call public, private, confidential, sensitive, restricted. All right, they would have all of that. Okay, so and when you're sending data to your vendor, some organization they won't just leave it as flat call this special category of data. They will specifically call it or give it the name of the classification, as it relates to their own organization. And that classification now will now determine how those data are handled. All of that you will find it in your information security schedule. Data encryption, access control. GDPR does not talk about, GDPR talk about data security. It's just
Yes.
it's a flat statement. It
Yeah.
doesn't go into specific. All right, but infosec goes into specific. All right,
Yeah.
you will talk about your access control, whether it's a single sign-on, whether it's a multi-factor authentication, whether it's just like a standard username and
Mhm.
password. All right, compliance and certification. GDPR doesn't talk about compliance,
No.
particularly certification. All right,
Yes.
but
Yeah. You're right.
InfoSec will say for a vendor, you must be ISO 27001
That's
compliance.
correct. Yeah.
You must be
Or cyber essentials.
9001
That's another one
or
they came
cyber
up with.
essential or
Yeah.
cyber essential plus. So,
Yeah.
InfoSec will call that out direct. Incident response and reporting. Well, GDPR, is not silence about that. It talked
Yeah.
about you reporting to ICO. But listen, what GDPR didn't do is just leave it at there. All right. It leaves you to work it out. But
Yeah.
under InfoSec schedule, all right, it is more explicit. All right. You will talk about different types of incident classification. All right. What P1 mean, what P2 mean, what P3, what P4. All right. You can bake that into the contract again. So you could say to your vendor, listen, only inform us when it is a P1 incident. And you clearly give a description of what a P1 incident to them, and that can go into the contract
Yeah.
as well. All right. Security audit and assessment. Yeah, we see right to audit under GDPR. Then
Yeah.
you could also have right to audit as well under InfoSec. Subcontractor and third party is the same as well as GDPR when we talk about sub processing. All right. Is the same thing as well. Security policy and procedure, you wouldn't find out under GDPR. All right, GDPR is silence about that. I mean, GDPR, you should have what we call administrative control. GDPR do talk about that. Again, he left it that way. It gives organization to give meaning to what, give meaning to it. But under InfoSec, you can have different policies. You can have your network policy, your vulnerability management policy, your incident management policy, access
Yeah.
control policy,
Yeah.
user access control policy, and all of that. That can also be clearly, defined under, InfoSec clauses. Data breach and liability and indemnity, the same thing as GDPR. Termination and data ownership.
Yeah.
Yinka,
Yeah.
does GDPR talk about data ownership? No.
Again, it's kind of like vaguely mentioned, but it's not as specific
Vaguely
as it would
mentioned. Okay,
be
as specific. All
in
right. Yeah,
infosec. Yeah.
data ownership is important, or what we
Yeah.
call asset ownership. All right. You remember when you give your data, all right, like in the case of the HR, you remember you're giving your data to them. All right. There must be something about the clause that talks about how they will return that data to you.
Yeah.
All right. Or how they would, completely delete them at the expiration of that
Yes.
contract. All right. So who owns the data must be clearly called out in the so that there's
Yes.
no there's, there's
In
no
fact.
there's no argument at the end of the
Yeah.
contract. All right.
Mm.
So ownership of data. All right. I mean, if you're a data controller, you would have responsibility for it. All right.
Yes.
In some way, you would own the data. So the overall responsibility should, be it. But
Mm.
InfoSec, it will clearly talk about somebody in that organization who has been saddled with the responsibility of ownership of that asset. All right. Monitoring and reporting. GDPR didn't say anything about that. GDPR just said that tell us where there is an issue. All right.
Yeah.
But in InfoSec, all right, there's emphasis around how you monitor the network,
Mm.
and how you report that, as well when there is an incident. Notification and requirement. GDPR talks about notification.
Yeah. It
The
does.
same thing is also,
Mm.
applies under IS. Yinka, is there anything that
Yeah.
you wanted to
Yeah.
add
Yeah.
here
There was,
before
yeah.
we
Two.
open the
Yeah.
floor for questions?
Okay. Two things I was going to quickly add. The first one is in terms of ownership. You do have clauses that would say, as you rightly said, at the end of the contract, you
Yep,
know, you get rid of our information. You won't hold it
yep,
for longer than necessary. So that's one. Another thing I was going to quickly mention as well, which I think we touched on yesterday, is where in when you're doing your due diligence, there's a section. It usually comes towards the end of the due diligence questionnaires where you'd say who owns the IP for this
yeah.
data that
Intellectual
we've
property.
shared.
Yeah.
Yeah. So you'll be looking at the answers they provide. So if they say we own it, then you look at the next one, which is usually follow on, where are you going to be using this data for test purposes? Now, if they
Yeah.
say yes, that's a red flag because it's our data and you're not
Data.
supposed to use it
Yeah.
for test purposes.
Mm.
And that's what
Yeah.
feeds into, remember I was saying it yesterday, feeds into machine learning, where,
Yeah.
so what you find some vendors do is, these vendors, what they do is they provide services to these people. You share your live data with them, and they go behind your back
Mm.
to use your data to test other software they're developing. And that's where
Mm.
they're using doing machine learning to teach the machine how to perform
The
specific
machine.
tasks
Yeah.
to provide
Yeah.
results. And then that's
You are even gonna talk to us more about that one.
yeah, because that's
About
what
this
feeds yeah,
this
because
this
that's what
new
feeds into
machine learning
AI.
stuff. Yeah.
Yeah,
Mm.
because machine learning is a branch of AI where you're trying
Yeah.
to improve the accuracy of your results.
Accuracy.
So you
Mm.
want a clause that says you will not use my data for that. And there's two ways of looking at that. One, there's the risk element, but then two, I don't want you to use my data to go and make money. So it's those kind of
Hmm.
things that
I
makes
hope
you
I hope
always
I hope everyone is listening. That's another very good one for you,
yeah,
which is new. All right.
it's new. Yes.
I mean, if you get to that interview and you're having a chat, it might just be something that you can throw in,
Yeah,
and said, "Oh, recently when I was reviewing contracts, this and this are part of what I'm looking at, particularly with the age of machine learning, chat
that's correct.
GBT, and all of that.
Yeah, that's right.
I'm
Yeah,
making sure that where we're exchanging data with, our vendor, we have a clause to protect us that
that's
our
correct.
data, would not to be sent to AI,
It will not
you
be
know,
used
uh,
for
it will
machine
not
learning
be
for AI.
used
Yeah, that's
for,
correct. Yes.
yeah.
Yeah.
Oh,
Okay.
that's a very good one.
Yeah.
That's a very good one.
Yeah.
Thank you, Yinka. All right,
That's okay.
guys. The floor is open. If you are, I know I don't know. Okay. We've gone a little bit above. Please,
Yeah.
if you have any question, let us know. The floor is yours. Any question, please? Any question? I will try my best. I will try my best to answer it. If I can, maybe Inka can help me out. Any question, guys?
Hello, Mr. Wale and Mr. Inka. How are you? Thank you for
Yeah,
the.
not too
It
bad.
seems I know this voice. I'm just joking.
Yeah, this is
All
K.
right.
Yeah,
Okay. Yeah. Go for it.
yeah, yeah. So this question is actually for Mr. Yinka. So I just want to ask a question regarding the GDPR, and Mr. Wale, you can help me as well. So maybe for both
Okay.
of
Yeah.
you, sorry, apology.
Yeah.
Yeah. So so talking about the GDPR, and they're talking about the financial service institution. So and they're talking about the new European regulatory requirement. I'm talking about
Mhm.
DORA right now. So
Yeah.
I'm
Yeah.
trying to understand because I was speaking to somebody today. It's like a director of information security, and he was mentioned. I mean, he mentioned to me that he doesn't think that DORA will have impact on the financial institution, particularly in the UK, but mainly
Okay.
for the Europe. But when you now look at that deep down and look at the requirement that surround DORA, you will
Dora.
understand that it's more of like a protecting the financial system, the network
Yeah.
and information
Yeah.
systems
Yeah.
that,
Yeah.
that they are using, and as well as the third-party ICT service
Yeah.
provider. So, and I was
Yeah.
like, okay, so that will definitely have impact on the in the UK financial institution, but how it's going
Yeah.
to be reflected, I don't know. But I try to put my question, I mean, my argument
Yeah.
forward
Yeah.
to him. But I know you guys are experts in this area. I just want to
Yeah.
hear what is your
I can
opinion in that.
before Inka come in, I can quickly comment on that one.
Okay.
So you see the person that said maybe he wouldn't have, I don't know what your conversation, whether he said he wouldn't have any impact or he wouldn't have a huge impact. Um, I would tend to agree that it may not have a huge impact. It
Mhm.
would have impact, but maybe not a huge. All right.
Okay,
And the reason is because if you look at UK market, UK is we're service driven.
that's right.
All right. Everything we do here is service. All right.
Mm.
And 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 because of that consciousness of the services, that we provide, we in UK we're very good at it. I'm not sure about other European country. So that's why, even before now, I've done networking for a very long time. Before now, you would have what we call highly availability, HA.
Mm.
So we would have a data center, we'll have another, DR. We would have a replica of it. All right. So and Dora is all about resiliency built into the financial service, isn't it?
That's right. Yeah.
Yeah.
Is that correct?
Yeah.
All right. It's all about
That's
Yes.
right.
resiliency.
Yeah.
That's
Yes.
that's that's the that's the crop of that particular regulation. All right, which is coming up. So it would have something, but it may not have like a huge. So it's not as if
Okay.
we're starting from the scratch. Let me quickly now say this. Where I think the area I think
Yeah.
that it would have some impact is with the use of cloud.
Mm.
All right,
Mm.
is with the
Which is
use of
probably the
cloud.
reasons for it anyway.
Yeah, which is probably the reason. So if you look at legacy network already have resiliency. I'm telling you, if something fail now, it will just fail over to a different service.
Yes.
Without you knowing,
Yeah.
you won't know. But
Mm.
Mm.
where I think the most impact, where the bulk of the work would be financial
Yes.
services that consume some services that lives in the cloud. Then we now have to be thinking about cloud DR.
Yeah.
Okay.
Yeah.
Yeah, cloud DR. There's
Okay.
going to be a whole lot of
Right.
market in that area for anybody that's listening. Cloud DR. All right. So it means that if you think about HSBC, they have a service which is very critical to their customer, lives in AWS. They have to go and look for another a replica of that service in Azure or GCP or any other private cloud. Do you understand? So
Yeah.
me personally, I think that area, there will be more market in that area. There will be more need to do more around cloud services. And truth be told, since COVID, we're just having a conversation now. Since COVID, a lot of services are moving to the cloud.
Yeah.
And if you consider those services critical, I use the word critical, not any just service. Critical, because you won't be spending so much on the DR service that is not critical. You know what I mean?
Yeah.
So if those services are critical, I think bank will tend to do more in that area. But I think that it would affect more of cloud services as opposed to
Mm.
legacy, services that lives
Mm.
in a typical data center or on-prem.
Mm.
That's my thought.
Yeah.
Inka.
Yeah, I think I'll echo what you said, because I think the way I would look at it is I would look at it in terms of territorial scope,
Okay.
because what you find is most organizations in the UK, they have a presence in the EU, and
Okay. Yeah, that's another one.
that's where they'll probably be captured by this. But it's still relatively not what's the word I would use? It's not something the UK has given a lot of thought to, except for maybe as you gave that scenario of the cloud in the financial sector. That's where they're looking at it.
Sector.
But I
Yeah.
don't think the impact will be felt immediately.
Yeah.
So that's my quick take.
Okay.
I think
Okay.
from a privacy professional, what is of more concern to privacy professionals at the moment, and that's something this is a takeaway for interview, is the data protection reform that's currently going through Parliament. So we have I know it's a slight digression, but I'm just trying to refocus from a
Okay.
privacy perspective anyway. We have the UK GDPR and we have the EU GDPR. So the
Yeah.
UK GDPR is simply the parts of the GDPR that the UK has retained, and they're more or less the same thing. So people just use GDPR. But just for your benefit to know, we have a UK one and we have an
Okay.
EU one.
And the
You
EU
want.
one.
So
Okay.
Yeah.
currently, at the moment, there's the DPDI bill which is going through Parliament, and it's called Data Protection and Digital Information Bill. And the idea is to reform the UK GDPR, because the UK's position is it's too prescriptive, it's not realistic, there's too many requirements, it's too bureaucratic. And in order to continue with the Brexit agenda, the UK is trying to change some of the aspects without jeopardizing their adequacy. I don't know if that resonates with you. So what they're trying, so there's a number of
Yeah.
things.
Yeah. Okay.
There's a number of things they're changing, like the ROPA requirement, DPIAs, legitimate interest. So that's a good read for anyone when you have time to go and have a look at that, because that comes up a lot in interviews. And the way
Absolutely.
they'll frame it is they'll say things like, "So you're the privacy expert or privacy analyst. So what's they won't prompt you properly. What they'll say things like, so what's trending? Horizon scanning. What is happening in the privacy world that you
The
think
different private
my
one. Yeah.
organization needs to be worried about?" And it's always a good point to raise, or even if they don't mention it, you could ask them in interview. Do you have any questions? Yeah, I have a question. The recent bill that's currently going through Parliament, where the government is trying to reform um, data protection. What is your position? And if whatever answer they give you, because if you give me the opportunity or you give me this job, that's the first thing I will be focusing on
I would.
and looking at what
Yeah.
you have in
Yeah.
place, all those kind of things. So that's what I wanted to add. But I don't think at the moment, we're going to immediately see Dora's influence at the moment. So that I just thought I'd add that.
Oh, okay. Yeah, I
Yeah,
mean, they still have
All
12
right.
months. They still
yeah,
have
yeah.
12
That's
months
right.
Yeah.
Absolutely. Yes.
to prepare. Yeah.
Yeah.
Okay.
Absolutely. But it's a good call, to be honest. Anybody that's
Yeah.
interested in that area,
Yeah.
and the way jobs open up, you can start to prepare and get yourself abreast with information, attend webinars, and you don't know when it just open up, you might just be the first person that will carry your head and enter there. So,
Yeah. Wale,
all right. Any other questions?
someone,
Sorry about my broken English question.
someone said, what is the difference between InfoSec schedule and InfoSec policy? I don't know if you saw that earlier. Are you
Oh, I
there?
didn't see that.
Yeah,
Oh,
yes.
okay.
Yeah,
All
what's the
right.
difference between InfoSec schedule
So,
and InfoSec policy?
yeah. So policy is an high level statement. Yeah, I would explain it. So policy is an high level statement. As okay, there are few. I haven't been checking this. So Ali, will the presentation be? No, we will not email it. But if you're registered, you would have access to it. Okay. Oh, okay, there are a few things here. Inka, let's look at some of the
Okay,
questions that is here.
okay.
All right. So, okay. I'm unable to view. Someone says they're unable to view. Okay. So
Mm.
it's fine here. All right. So I'm able to see the screen. Okay, that's fine. I'm just looking at the question. So let's have quickly. Okay, what is the difference? All right. Someone says, so what is the difference between that is my Ismaila or Ismaim or something like
Yeah,
that.
that's that one.
Says that what is the difference between InfoSec schedule and policy? So policy is usually high level statement, okay? And policy, you could have different policies on different. I cited an example earlier on. You could have a vendor management policy, you could have third party risk management policy, you could have user access policy, you could have risk management policy. So usually high level statement, and we also call them administrative control as well. All right, they are there to help you, guide, the conduct of your organization. So they are there. Administrative policy to guide different. All right. So I said schedule earlier on. Schedule in other words, you could also call it as well. So schedule is like a compilation, of different controls. All right, that you want to see your organization apply. All right. Of course, when you read your schedule, sometimes you can see some inference of the schedule in your policy, but they are two different things. All right. So schedule could be like the example that I cited earlier on. It could be, how you want a third party to protect your information address, thereby applying encryption. So in the schedule you typically explain what sort of level of encryption that you would expect. All right, and in a schedule also can contain information around access control. In a schedule you would explicitly called the sort of access control, whether two-factor authentication or single sign-on, and the scenario where it should be used and how it should be used. All right, in a schedule you could talk about your network security. In there you will talk about firewalls, and how firewalls should be applied, or how it should be used to protect network, so that wherever, even if you're sharing data with the vendor, that would also be protected as well. So there are two different things. But you see, when you're reading your schedule and you're reading your network policy, all right, or you're reading any of your policy, there must always be a relationship. All right, you will find an element of what is in your schedule, in your policy. It wouldn't be, it wouldn't be parallel. You know what I mean? Okay, you would find an element of what you're saying in your schedule, in your policy. But your policy, guess what? It is addressed, all right, to your staff, or also, to your contractor and vendors as well. All right. So whoever is going to do any piece of work for you, they could go read your policy because it's a part of your control. All right. But the way it's written, will be different. Any other question there, Inka?
There was just the
Before we leave for
one.
tonight. AI is an
What
emerging
was that?
stuff.
No,
Wale
there
and
was one.
Yinka with the presentation of the slide. Yeah, we talked about that. We will
Um,
not email it, but we would have it
oh,
available. Is the
there was one
vendor
about.
due diligence carried out by InfoSec?
There's one
Uh,
about statement of works. Is a statement of work like an addendum? And I was going to,
Okay.
yeah, I was going to quickly add.
Yinka, do you want to answer that?
Yeah. So an addendum is like an addition to a
Yeah.
contract, or an addition to a contract. And all it simply means is once all the parties have agreed with the addendum, then it forms part of the whole contract. So if you look at it from the scenario of a
Yes.
statement of work, you could actually have an addendum to a statement of work. It's just essentially an addition, was maybe because of more requirements, or there's other things that have come up. So
Yeah,
it's
what's
an
already
addition
agreed.
to the existing contract, which all the parties
Yeah.
have to agree to, and then now becomes embedded into the contract. So it's not exactly a difference. It can be the same thing, but
Yes.
I think the main thing to always remember is, because sometimes when you're looking at these contracts, there was the division you gave earlier, Wale, but sometimes you could just have it as one great big contract and all those things are
Mm-hmm.
roped into one. Or you could have where they're all separated, or you could have a scenario where you have a contract and then there'll be another schedule or statement of works that is added to that contract. So it's clear it's just an addition, which now gives more specification, and then it becomes part of the whole contract. Yeah. So that's the way I'll tackle that one. And I think Wale,
All
there's
right.
the last one.
Thank you, Yinka.
Is the vendor due diligence carried out by InfoSec? Does it include a check of vendor financial stability? Do you want me to give my take on that one?
Yeah.
Yeah.
Yeah, go on. No, give your take on that one.
Okay, you know, you gave an earlier point where you said that infosec or privacy analyst, you're not the one, you don't own the contract, and neither are
Yeah.
you going to be the one that will look at the finer points of the contract. I think the same applies to this. So if I look at some real world scenarios I can remember, procurement, supply chain, that would be their job. So they would be asking, you know, necessary questions like things before the supplier is onboarded. Okay, they will be the ones that would look at their financial position. Are they giving us the right account details for payment? Have they given, so that wouldn't necessarily fall into the remit of infosec, because you know that's more to do with the finance teams, procurement,
Yeah.
supply chain, and all. You just, as the schedule that Wale went through and the different phases is what you'll be looking at: infosec requirements, privacy requirements.
Yeah.
Yes, if you see any red flag, so I mean, so
Of course.
financial stability, what would I look for to work out financial stability? um you it's really hard for an infosec professional to say he's trying to work out the financial stability, unless maybe there's something that comes up in terms of things like maybe they're not PCI compliant. You could go down that angle, but really I wouldn't say that sits with infosec.
It doesn't sit with infosec. As a
No.
matter of fact,
Yeah.
I did a piece of work for an asset management. And part
Okay.
of our due diligence, we have that bit where they go check for financial stability of that organization. We don't get involved in it. I
Okay.
think they have a way of checking, and they have
Yes,
certain parameters that they use.
absolutely.
All right.
Yeah.
And the business would do that. We don't get
Yes.
involved. All
Yes.
right. But like Inka said, is a red flag as well.
Yeah,
If they are not financially stable, then you can't do business with them.
that's
But
correct. Yeah.
it's not within the remit of what you do. Business will do that.
Yes.
Okay. I
Yeah.
think that's it,
Okay.
guys. Except if anybody have any question in the 1 minute, 2 minutes. All right. Okay. So thank you all. I think we had about 20 people. Thank you.
Someone said, Mr.
Um,
Wale,
Thank you very much, Wale.
someone,
someone said, can you
someone.
please in the future do something on AI and the possible risks? I got a question related to AI today or something like that. Okay.
Nika, they're calling you
Uh,
there.
And Mr. Wale, the questions was actually related to third-party risk management. I was just lucky because I have a simple idea of it. To be honest, they just put it to me. You did a due diligence and you discover that one of your vendors is using AI. What is the
Ah,
possible risks that could result from that? I just said
okay.
data loss. That's what I said, because you are not sure of who the AI is sharing the information with
yeah.
and the necessary security in place. But I don't know if I answered it correctly. I just want to share with the
Ed,
team.
okay. Yinka,
Mm.
did he try with the response?
Yeah, he did try with the response because, okay, for instance, I can give a quick example, which I hope is a bit relevant. So, for instance, now, in one of my previous roles, the company wanted to introduce AI, and I'll use the term generative AI, which is like
Okay.
ChatGPT and some other ones. And the reason why is because they want to be using creative content. So they want to be able to type in something and gives them ideas. So the business was happy with that. But we stepped in and said, hold on, there's going to be risks with using AI. And as you rightly said, it's outside of the estate of the
Yeah.
organization. By using the word estate, what I mean is InfoSec would not have visibility of where that data is held, who it's shared with. And we also found human beings are human beings. Sometimes instead of, if I work for a company called, I don't know, Yinka and Sons, instead of me to take out that Yinka and Sons, I'll just copy the whole question and paste it into chat GPT. But that's commercially sensitive information because you've put the name of your company and whatever the question is. You don't know what's happening in the back end of AI. So what we've had to do to counteract that is come out with an AI policy, which means if you're going to be using um, things like generative AI, which is ChatGPT and other AI tools, you must remove all commercially sensitive information. In the event that we find you've used commercially sensitive information, so we might put like a pop-up which would say, "Are you sure you want to put this in?" If the person is working in automatic pilot and they just put it through, it will raise a flag. You'll face a disciplinary. But then I've attended seminars where they've said that is still a risk because you don't want them to use AI at all because of intellectual property and so many other examples. There was one, I'll be very, very quick. There was one big case in New York where an American lawyer, he was trying to defend a client and he went into ChatGPT to look at cases, and ChatGPT gave him a number of cases. So he presented that in a court in New York. And normally, the judge, he actually said himself that he doesn't normally question these things because the opposition were like, "Hold on, how come we're not aware of these cases?" He said, "No, no, no, they're valid cases." And then the judge now said, "Okay, for me to deliberate on this case, I'm going to go and look at those cases." And the judge couldn't find the cases. So the judge said, "Excuse me, you
Where did
presented
you
these
get
cases,
this
but we
from?
can't find them." So now the lawyer now realized, oh, ChatGPT actually made up these cases. It was a big thing.
Wow.
And in the end, that law firm was fined. The lawyer himself was fined because what they said is you should have done your due diligence. Just because
Before
ChatGPT
presenting,
has
yeah,
mentioned this
yeah.
case, you should have gone to verify.
It doesn't mean that.
Yeah, it doesn't mean that it's because you have to remember ChatGPT is
Yeah,
gathering information from various databases, compiling
and
it
making it up.
and making it available. Yeah. So in a way, your answer
And
is
again,
yeah,
Yinka,
yes.
yeah, I also wanted to add for you, Mr. Kazim,
Yeah.
I wanted to add that some jobs that I've done, when we're doing privacy assessment, PIA,
Yeah.
which could lead into data privacy assessment.
Yeah.
So the 10 questions that you ask, whether you're using a destructive technology like AI. The moment that is yes, all right, of course, all right, that's a high risk.
Yeah.
Then you now take it to the DPIA, all right, where that's that's a whole different assessment in its entirety. Anything that had, in fact, you know what privacy assessment is now. When there's a smell of AI or any disruptive technology,
Yeah.
it raises a red flag, and you start to assess them. I think so. Another thing you can take away, Mr. Kazim, is, AI, is a disruptive technology, and when you use such technology, under data protection regime, there will always be need for you to carry a privacy impact assessment. Um, when you're using the AI. The example that you cited in terms of what you said, data loss, yeah, you are correct. In the real world, um, if you find yourself on a project where they wanted to use such technology, then DPIA would be required. All right.
Okay.
Any other questions? All right. So, ladies, gentlemen, I just want to say thank you. Thank you for holding for. Yeah. Thank you to everybody that joined. I know a lot of people have dropped off,
Yeah.
but I hope this has helped you in a way. So I hope the content is great, and we've helped to answer some questions, remove some doubt, and maybe you are better armed with information now if you're going to the marketplace to look for a role. We'll make the recording available as usual. We'll have it in our portal. If you haven't registered, just do so. Then we'll push the content. It won't be ready today or tomorrow, so don't message me, please. But on Monday, hopefully, if I talk to Timothy, he might be able to do it for us. Monday, by God's grace, we should be able to push it out to everyone that registered. All right. Like I said, I hope this has been useful. Yinka, thank you so much.
No problem. Okay.
Yeah, thank you for
Thank you
supporting
so much,
this.
Wale and Yinka, for the course.
Yeah.
Yeah.
All
Thank
right,
you very
guys.
much.
So yeah.
Okay then. See you later.
You're welcome.
Thank you, everyone. Good night.
Yeah.
Thanks, Wale. Thanks,
All right.
Yinka.
Good night, everyone.
Okay.
Bye.
Bye-bye.
Bye.
Bye.
Good night, everybody.
Bye.
Bye.
Bye.